Did you know that parents rank teaching financial literacy as the toughest life skill? That's where Greenlight comes in, the debit card and money app made for families. With Greenlight, you can send money to kids quickly, set up chores, automate allowance, and track spending with real-time notifications. Kids learn how to earn, save, and spend responsibly, while parents have peace of mind knowing smart money habits are being built with guardrails in place. Try Greenlight risk-free today at greenlight.com/Wondery. That's greenlight.com/Wondery.
Parles-tu français? Hablas español? Parli italiano? If you've used Babbel, you would. Babbel's conversation-based techniques teaches you useful words and phrases to get you speaking quickly about the things you actually talk about in the real world. With lessons handcrafted by over 200 language experts and voiced by real native speakers, Babbel is like having a private tutor in your pocket. Start speaking with Babbel today. Get up to 55% off your Babbel subscription right now at babbel.com/Wondery. Spelled BABBEL.com/Wondery. Rules and restrictions may apply.
Hey, fans of freedom and open discussion, I'm heading over to Substack, and there's an ad-free audio and video version of The Adam Carolla Show that's going to be waiting there. In the near future, you'll even be able to watch ACS Live, unedited, as we record it, participate in the show via live chat. That'll be coming up very soon. You'll also get an ad-free version of the Adam Carolla and Dr. Drew Show. You'll also get an exclusive to my new podcast, Beat It Out, where I share unpolished ideas with my comedian buddies. The first series of episodes is going to be Jay Moore. You'll get all this and more for the low, low price of $9 a month, a pittance for all we're going to bring you. Subscribe now at adamcarolla.com/Substack, and I'll see all of you in our new speakeasy called Substack.
I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome to the Prosecutor's Pod. Nope, that's definitely not the sign-off.
It's been a while.
Welcome to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined as always by my major co-host, Brett.
Oh, so major, not questionable at all.
You are a major question mark, but,
I don't know what that means.
That is so nerdy. All of you guys listening to this, first of all, you're already certifiably nerdy because you're wanting to listen about IEPA. And if you don't know what IEPA is, you're about to learn, and you're about to listen to another episode of this season of SCOTUS. So you are nerdy, and you can appreciate my nerdy major questions joke.
The first case I ever worked on as a real lawyer was an IEPA case.
Really? They don't come along that often.
It was under ITAR, which is the Iranian trade. ITAR under IEPA, so both of them. Statutes were implicated. Yeah,
that kind of shows your age a little bit, because I also worked on IEPA, but I was doing Brazil IEPA in Trump 1, so that's like what, 10 years after you?
Yeah,
not quite, maybe 8 years after you.
This was 2007-ish.
Yeah. Wait. So. You're not that much older than me, are you? I hadn't graduated from college.
I graduated from law school in 2007.
Really?
Yeah.
I'm sorry. Sometimes I like to feign just making you feel old.
I've been a lawyer for almost 20 years. We've got on 20 years of being a lawyer.
I still don't believe you're a real lawyer. Says Reddit.
I know. Well, there's plenty of people who don't.
Says Reddit. Well, guys, all this banter is because, actually, IEPA is fascinating. This season of SCOTUS, as we've told you about, is actually fascinating. And this particular case, you can click on all the headlines. It can be big P politics, little P politics, everywhere. We're just trying to give you what the arguments were, because this was recent. This was the most recently argued case at the Supreme Court. You can listen to all of the Supreme Court arguments via podcast from the Supreme Court website. This particular one was like 2.5 hours. You know, they've really drifted away from keeping arguments to an hour. Like, we're not even close to the hour range anymore. We're just straight up in the talk as long as you want.
Go as long as you want.
Talk as long as you want. We talked about this. This is because of COVID. When COVID happened, the Chief Justice started the whole, like, going after time was over, he would just go down the line and ask every single justice if they had any last questions, because you can imagine doing these arguments. They wanted to make sure everyone had a chance to ask questions. But now it just means that time means nothing at the Supreme Court.
It's true. It really doesn't. And I'll say this about this case.
We're talking about Trump tariffs. I'm sorry. That was a long roundabout way to say this.
This is learning resources versus Trump. It's about President Trump's tariffs on the world. And this, listen to this argument. Fascinating. We've listened to a bunch of arguments and we talked about them. This was the most poorly reported argument that I think I've seen. I was really, because I didn't listen to it live. I read all the commentary. Then I listened to it and I was like, wow, this is completely different from what everybody's saying. So we'll let you guys decide for yourself. But hopefully after we talk about this, if you really are interested in it, with a little bit of background, you can listen to the arguments for yourselves and draw your own conclusions. Because if you try and listen to it, it's like confusing. There's all these weird acronyms. They never explain them. You have no idea what they're talking about. But we, your humble podcast host, are going to explain it all to you.
All to you. You're going to understand IEPA and international trade and tariffs and non-delegation doctrine and major questions doctrine, all by the end of this snappy 25-minute episode. Just like the Supreme Court. We never stick with our time limits either.
So let's get started. And we're going to start with a little bit of a historical case, because it's one that came up multiple times during the argument. It is one that underpins a lot of these discussions about presidential power, and that's Youngstown Steel. Now, you don't have to read the main opinion by Hugo Black, because nobody cares about that. The most important opinion is Justice Jackson, then First Justice Jackson's concurrence, where he sort of lays out what has become the lodestar for presidential power and how broadly we interpret presidential actions. And so we're just going to read to you the 3 categories that he created. And this is exactly what he said. We are quoting from the opinion. So category 1, when the president acts pursuant to an express or implied authorization of Congress, his authority is at its maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. In these circumstances, and in these only, may he be said, for what it may be worth, to personify the federal sovereignty. So this basically what Jackson is saying is this is as close as you can get to having the power of a king. I mean, he personifies the state. If his act is held unconstitutional under these circumstances, it usually means that the federal government, as an individual whole, lacks power. So basically, if you're in zone 1, the only thing the president can't do is what the federal government could never do under any circumstances. A seizure executed by the president pursuant to an act of Congress would be supported by the strongest of presumptions and the widest latitude of judicial interpretation, and the burden of persuasion would rest heavily upon any who might attack it.
Justice Jackson's second point about the president: when the president acts in absence of either a congressional grant or denial of authority, he can only rely upon his own independent powers. So we're talking about the 2 sides of the spectrum. But there is a zone of twilight in which he and Congress may have concurrent authority, or in which its distribution is uncertain. This is like the definition of a gray area. Therefore, congressional inertia measures on independent presidential responsibility. In this area, any actual test of power is likely to depend on the imperatives of events and contemporary imponderables rather than on abstract theories of law. Third.
So that's the murky middle there.
Yeah. The murky middle with imponderables.
Yes.
Basically, it's like, I'm going to do this thing like where you lick your finger and feel the wind because we're not exactly sure and it's going to be very fact dependent on whatever's happening at that very moment. Third, when the president takes measures incompatible with the expressed or implied will of Congress, his power is at its lowest ebb. For then he can rely only upon his own constitutional powers minus any constitutional powers of Congress over the matter. Courts can sustain exclusive presidential control in such a case only by disabling the Congress from acting upon the subject. Presidential claim to a power at once so conclusive and preclusive must be scrutinized with caution, for what is at stake is the equilibrium established by our constitutional system.
So this is important because what we're talking about here is trade and tariffs. And the Constitution places that power squarely within Congress. So if you read Article 1 of the Constitution, go to Section 8. Among other things, Section 8 says the Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States, blah, blah, blah. Imposts and excises, to regulate commerce with foreign nations and among the several states and with the Indian tribes. So generally speaking, the power to tariff is one that is placed with Congress. So there are things the president can do that are sort of within his power. But generally speaking, under our system, if you're going to have a tariff on another country, Congress has to pass it, the president has to sign it, and then it becomes law, right? In the vast majority of our tariffs, that's how it works. So you may be asking yourself, well, then how is it that President Trump is now saying, well, I can just tariff all of these countries? I mean, isn't that just on its face unconstitutional? Well, the problem is, remember, what was it that Justice Jackson said? If Congress delegates the power to the president, then all of a sudden he has it. And that's what this fight is about. It is about a statute called IEPA, the International Emergency Economic Powers Act of 1977. It is a successor statute to the Trading with the Enemies Act of 1917. And the thing about this statute, and one of the reasons I always enjoy talking about this stuff, is because people are completely ignorant of some of the actions your government has taken. And one of the things they've done, like if you were really just up in arms about Trump doing this thing, we're about to read to you what Congress did and what power it delegated to the president. And frankly, it's crazy. It is wild. So let me read this to you. First of all, it states that during an emergency declared by the president, and by the way, everyone agrees, and everyone in the argument agreed, and all the justices seem to agree, that the power of the president to declare an emergency and define its borders is basically unreviewable. And to the extent it is reviewable, it has like the highest deference imaginable. So the president just has incredible authority to say there's an emergency. When he declares an emergency, and by the way, if you're thinking of like enabling acts, which often pop up in various dictatorial countries, yes, that's essentially what we're about to talk about here, because IEPA is as close to an enabling act as you're ever going to see. So if the president declares an emergency, this is what it says the president may do. The president may, under such regulations as he may prescribe, by means of instructions, licenses, or otherwise, investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of, or dealing in, or exercising any right, power, or privilege with respect to, or transactions involving any property in which any foreign country or a national thereof has any interest by any person or with respect to any property subject to the jurisdiction of the United States.
That's really broad.
That is incredibly broad, like shockingly so. When I read it, I couldn't believe it, how broad it is.
So both of us have litigated the statute before. And I will say the first time I litigated the statute, because it was new to me, it was in the Court of International Trade, where in the lower courts, that's where it would go. I remember reading a draft of the brief and thinking, there's no way this is correct. Like, there's just no way this is correct. Like, let me recheck all the cases that we cited. It cannot possibly be this broad. But alas, after reading basically all the case law over the last, 50 years, it is in fact that broad. And there is some quibbling because IEPA replaced another trade statute where they removed like 3 of the 28 verbs.
It was even broader. Yeah.
Like, it was even broader. And I don't even know how you settle upon the 3 verbs or so that you removed. But I mean, usually you could just basically say they can do anything they want. But to make sure you know just how broad it is, this statute lists all the different types of actions that the president can take.
What's amazing about this statute is it managed to use very broad capturing everything language or otherwise. And then it's but let's just go ahead and list every possible verb we can imagine. Now, listen, one of the verbs that's not in there is impose tariffs, right? It doesn't say impose tariffs. So one argument you might make is, look, they put everything under the sun in there. They didn't put tariffs in there, so therefore it doesn't mean tariffs. Well, the problem is the language that's important and the language that the Supreme Court discussed throughout are both or otherwise, which is pretty broad, and the provision to, quote, regulate the importation of. So the Trump administration's position is generally going to be that is where this power to impose a tariff comes from.
And when you look at statutory interpretation, obviously look at the meanings of the words. I mean, what is imposing tariffs? This is the whole argument right here, right? But you can see where the Trump argument is coming from, where you're using tariffs to regulate importation of ... anything else. So,
and I'll just say, the thing about this that's so striking, if this weren't so controversial, if this were just a run-of-the-mill case, I think most people would be yeah, tariffs.
That is regulating the importation of.
No big deal. That's part of the regulations on imports, right? But obviously, that's the core of this case. So it becomes a really big deal what that means. And as we're going to see, sort of the arguments about how broad that is, whether a tariff is a regulation or whether it's something else, that's what's going to be at the heart of this argument.
This really is a callback for those of you who followed many seasons of SCOTUS back to the Obamacare or Affordable Care Act case of whether it's a tax or, right? I mean, that's the exact same question. They raise this at the oral arguments as well. Is a tariff a tax or is it regulation? And that is kind of the core question here because, of course, the statute says to regulate. And you can see how the exact same thing can do 2 things. This is kind of like when we say the mens rea, okay, here is a perfect example. My 8-year-old, he's very much in a phase where he's very literal. And so we have a chair that rocks in our living room. It used to be a nursery chair and it's now in the living room, which is a huge mistake. Mom should have never put it there. But what do you think my kids do every single day? They see the chair and then there's a magnet that draws them. They run and catapult across the entire living room and dive into the chair, which causes it to flip backwards and hit the wall. So I have told them 1,000,000 times, do not jump on that chair. You're going to put a hole through the wall. What happens yesterday? 8-year-old takes a running dive. As he's in the air, I'm like, don't jump on the chair. He jumps on the chair with such force, it falls back, puts a hole in the wall. And I said, dude, you put a hole in my wall. And he said, I didn't mean to do that. I was just jumping. Right? And so the jump and the hole are clearly tied. But he was saying, I didn't mean to tax anything. I just meant to regulate. That really, honestly, is a huge core of this argument because you can see how there's both sides are right in some sense.
It's interesting because it's also a statutory interpretation question because, what matters? Was it his intent that mattered, or is it the consequences that mattered? And they're going to talk about that here as well.
Absolutely. And not just the consequences, but the not even unintended, but the absolute intended. There's no way you can punch a wall without breaking it. There's no way you can impose a tariff and not extract some amount of money, right?
But one question might be, did Congress intend to give the president this tariff power? And, at least one justice is going to say we should look to their intention. And the other justices are going to say, no, all that really matters is the result. Like, if the statute itself gives them the power, whether Congress intended it or not, doesn't matter. Which is kind of like, there's a hole in the wall. Doesn't really matter what you intended. Right. And so
we had a whole, I just listened to this argument, so we had that whole intent, and he was not following me. But now I have a hole in my wall, by the way. So if anyone wants to help me fix it, that'd be great. Automate your alternative resolution program with Diversion Manager. Diversion Manager is a proven web-based software platform that automates and manages diversion programs. The platform benefits prosecutors' offices and communities by quickly disposing of system clogging, low-level crimes, holding participants accountable while providing them with a second chance. Diversion Manager is used by over 600 agencies across the U.S. and provides over 30 online behavior-changing courses addressing a wide variety of traffic and misdemeanor violations, and has been shown to lower recidivism rates.
Diversion Manager's advanced workflow automates screening, communication, and disposition, eliminating manual steps. It manages processes including registration, fee handling, and document upload verification, increasing productivity. Your office can dispose of hundreds of cases in a matter of minutes rather than days. If you need the support of our fully functional platform, which can be configured to accommodate the automation and management of alternative programs with advanced workflow, communication, reporting, and integration with your case management system, then you need Diversion Manager. Go to diversionmanager.com/podcast to learn more and to schedule a demonstration of our fully functional platform. This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game, shifting a little money here, a little there, and hoping it all works out? Well, with the Name Your Price tool from Progressive, you can be a better budgeter and potentially lower your insurance bill too.
You tell Progressive what you want to pay for car insurance, and they'll help find you options within your budget. Try it today at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states. Okay, back up before we get to the imposition of these tariffs and whether it's regulating or it's tax. We have to have an emergency first under IEEPA. Well, if you remember, Trump declared an emergency regarding fentanyl imports and the exploding trade deficit that resulted in, quote, hollowing out of our manufacturing and industrial base. So that is the emergency he declared, and that is what he uses in order to invoke all of these powers that are given to the president under IEEPA. So to address this emergency, Trump used IEEPA to impose trade tariffs on just about everybody, but numerous foreign nations. So not just one, not just two, friend and foe alike, and they were very high ones. Now, Trump argued that IEEPA grants the president incredibly broad powers, including to regulate importation, which those words come straight from the statute. The government argued that this means tariffs. Importation, regulation is tariffs. And that's what they were doing. So, as Justice Thomas has been doing for the last several years, basically since he broke his silence during oral arguments, after Scalia died, that's right. Has it been that long? So actually it's been like 10 years. I thought it was a couple years, but it's actually been 8 years at this point because I actually remember this. Almost 9 years because I was pregnant at the time. You know, life is wrapped up in SCOTUS. Okay, so Justice Thomas usually comes in at every oral argument with the first question, and he comes in with a very pressing question and kind of where I started.
A major one.
A major question, shall we say, how we started with our descriptors. He said, guys, are we missing something here? Doesn't the major question doctrine not apply here? Here, because the president has extreme authority over foreign affairs, you would expect him to have the major powers to deal with major problems. And he cites to Youngstown Steel. And so he's saying, why is this not invoking the major questions doctrine here?
And the he, by the way, is John Sauer, who we talked about before, who is the Solicitor General of the United States. He is the one who is representing. There's actually going to be two Solicitor Generals in this case. The current Solicitor General is representing the United States, and a former Solicitor General is representing the challengers. So you got some really high quality litigants here. And the major questions doctrine, for those of you who don't know, really kind of came out of the pre-getting rid of Chevron thing. Because you had the Chevron doctrine that said courts need to defer to administrative agencies. And so what was happening more and more is administrative agencies would find some relatively minor clause in a statute, and they would say, hey, this gives us the authority to completely reorganize the American economy. And at some point, the Supreme Court started saying, look, we're going to have something called the major questions doctrine, and it's going to say, if this is a major issue requiring an extreme use of authority that isn't telegraphed by Congress, then we're going to look askance at it. Like, you can't just use every jot and tittle of the statutes of the code to do these insane things. We did an episode on the forgiveness of student loans in the Biden administration. And there was a statute, and they were trying to use like modify and a couple other verbs in the statute to say that means you can forgive all student loans. The Supreme Court said, look, no, this is a major questions doctrine. If the Congress had intended to include the authority to forgive trillions of dollars in loans, they would have included it in the statute. They didn't. Therefore, you don't have the power to do it. So Thomas is saying, hey, isn't this major questions doctrine? You've got this statute that you're trying to read this incredible power, a power that, by the way, originally rested with Congress. You're trying to read this incredible power into it when it's not explicit. If Congress meant to give the president the power to tariff people, wouldn't it have said that in the statute? And so then, as Al said, the government comes back and says, no, look, the president already has this sort of foreign-facing thing, and these are about big questions. And so you would expect big powers to go along with it. And so then Justice Kagan jumps in on this and starts to talk about, you're talking about inherent Article 2 powers. Sure, the president is foreign facing, but those powers are inherent to Article 2. And guess what? Tariff power, the founders specifically decided to give that to Congress, really based on some of our experiences with the British and Parliament and the tea tax and the Stamp Act and all those other things, right? So what's interesting about this is then sort of the government is falling back on this delegation. They're saying, look, you're right. You're 100% right. The president doesn't have these inherent authorities, but this is a delegation. This is Youngstown 1. And this is the first time that Sauer brings up Youngstown 1. And he says, look, you can have the power to tariff, and you can do it in a regulatory way. This is not a revenue-raising tariff. The whole point of this is to regulate imports. And in fact, best case, we'll never see a dime from this because it'll deal with the emergency. And this never came up, and this may be a stupid analogy, but I'm going to use it anyways because it's the first thing that came to mind to me. Machine guns, automatic weapons. If you live in the United States, you probably think it is illegal to have an automatic weapon. You are wrong. It is not illegal to have an automatic weapon, but you have to pay your taxes on it. There is a tax that you have to pay, and if you don't pay the tax, you can't have this weapon. So if we have a machine gun case, the first thing we do is check to see whether or not you have a tax stamp. And if you have a tax stamp on your machine gun, well, we got to drop that charge because it turns out you can have it. Now, it's incredibly difficult to get the stamp to pay the taxes. So really, it is virtually illegal, but this is an example of something that's ordinarily revenue raising, a tax stamp that in fact is used to regulate the possession of machine guns. So to me, that's what I kept thinking. Like, you keep saying this isn't revenue raising, even though normally it would be. It's regulatory. Well, this feels a lot like that. Feels a lot like the machine gun type situation. And that's the argument that the government wants to put forward.
And so Sotomayor jumps in with the counter of the argument. She's like, no. Like, potato. Tariffs are taxes. It's not like, say, something like a quota, for instance. That's not revenue raising or a tax. And the government keeps saying, no, we are foreign facing. So this is not revenue raising. They keep falling back to we're regulating importation. So Sotomayor gives a hypothetical. She says, okay, if we're going to view this as like a political question, let's say that President Biden declared a climate change emergency. And because that's really unreviewable, the ability to declare an emergency is full presidential power, right? So he declares a climate change emergency. That's foreign facing. Does that all of a sudden mean that President Biden would have unlimited power to do anything and everything to address this climate change emergency? And John Sauer comes back and says, again, no, this is just regulating the importation of not taxes. See, I got a little bit, I fell into the trap. Sotomayor got me. And Sotomayor shoots back and says, okay, you're calling it regulation, I'm calling it taxation, but let's look at Congress. Whenever Congress talks about taxation or regulation as taxation, they use the word taxation. You're trying to read something into the statute that's not there. You're trying to say regulation and you're trying to rebrand what taxation is. But if Congress wanted to give the president the power to do this as taxation, they would have just used the word taxation. And guess what word doesn't appear in this litany of words in IEPA? Taxation.
And this is important because not only is the tariff power very clearly within Congress's purview, but taxes are absolutely
100%.
I mean,
they're the purse.
Just the most.
Right? We always know Congress has the purse strings.
Power of the purse. Exactly. The most fundamental power of Congress is taxation. And so if these tariffs are really taxes, then that's even more of a problem because you're no longer regulating imports, you're taxing. And we all know that a tariff is a tax, right? So you put a 20% tariff on an automobile and you go out to buy an automobile, guess what? It's going to be a lot more expensive than it was the day before. That's how it works, right? Some of that might be borne by the importer, some of it might be borne by the company, but some of it's going to be borne by you. And either way, that money is all going into the treasury, so therefore it's taxation, right? It's revenue raising. Now, a couple of interesting things about this question. Sauer basically says, yeah, if President Biden had done that, he could take those actions. And it's just so funny to hear this because obviously, if President Biden had declared a climate emergency and slapped a bunch of tariffs on fossil fuels, conservatives would have been running to the courts to say you couldn't do that. And Justice Sotomayor probably would be saying, oh, no, this is fine. You're right. This is fine.
We have to regulate. It's an emergency, right?
Major question. Right, exactly. So it's just funny to see how it flips. Now, I mean, I guess to the government's credit, they're like, yeah, sure. Because they
kind of have to say
by
that,
the moment.
By the way.
And they
kind of have to say that right now.
Yeah. I mean, it was a perfect gotcha question.
It would have conceded their entire point, if not. Because I don't think you can draw a distinction, for purposes of their argument.
This wasn't something Sotomayor just came up with on her own. This was in the briefs from the other side. And this is smart litigating, right? Because people like Justice Thomas don't want a president to have the power to declare a climate emergency and then tax oil. He doesn't want that, right? So you're trying to use that to say, see, so there has to be a limit because you don't want this to happen on the other side. Even though that really shouldn't be what makes you decide what the president can do or can't do. But so this is really interesting. Now, what's funny about Justice Sotomayor's point, Alice has already mentioned this, the Affordable Care Act, Obamacare. Those of you who may recall, when it went to the Supreme Court, one of the big issues was the individual mandate, the government commanding you to buy insurance. And the argument made by people who opposed that was this is a violation of the Commerce Clause. You cannot force people to buy things. You can regulate commerce. You can limit commerce. You can do all that sort of stuff. But what you can't do is walk into my house, point a gun at me and say, buy something, which is essentially, when there's a government law, it's force, right? And they went on that. The Supreme Court said, yeah, violates Commerce Clause. Can't do that. But the problem is, it's actually a tax. Even though it's not called a tax, it's actually a tax. The individual mandate is forcing you to spend money, and what the government can do is force you to spend money, so it's actually a tax, even though it wasn't called a tax. So you see how these, that was 13 years ago, and now all of a sudden, what you call it, is it a tax? Even if you don't call it a tax, it suddenly becomes important, right? So that's where we are on that. So then you have Justice Jackson. She comes in. And the thing I'll credit Justice Jackson with, I don't know, she gets criticized for this, so I don't know if this is to her credit or not. But the thing about Justice Jackson is she is just not that interested in making friends and gaining supporters on the Supreme Court. You see Justice Kagan, you see Justice Sotomayor, they're making originalist arguments, they're making textualist arguments, they're making all these arguments that they know will be attractive to the conservatives on the court. Justice Jackson's just let's talk about legislative history, which literally no one cares about on the court. Now, look, when Justice Scalia in the early 80s was talking about originalism, nobody cared about it either. And there were 8-1 opinions where Justice Scalia wrote dissents, which are now the law of the land, right? So maybe she's sort of setting herself up like that for the long game, like trying to bring back this interpretive way of looking at things. But she wants to talk about the legislative history and to basically say, look, IEPA was passed after Nixon. They weren't passing IEPA to give the executive more power. They were passing it in reaction to Nixon's excesses, we'll say. And that's why they're replacing the Trading with the Enemies Act. In fact, Nixon did exactly what President Trump has done. So there was a large trade deficit. Nixon said, I'm putting a 10% tariff on every country in the world to address this. This is an emergency. I'm going to do that. And basically, this led to various trade agreements, and eventually that went away, but it was litigated. People opposed that. People said, hey, that's not right. And then subsequently, you had IEPA come out, and she's saying, look, I don't think Congress would be trying to give broad powers to the president. This is actually meant to limit presidential authority. But what the government is able to point out is that the language that is relevant here is the same as it was in the Trading with the Enemies Act, with TWIA. Like, I just call it TWIA the whole time. And because they kept the same language, you should interpret it the same way. And since no court struck down Nixon's action and in fact endorsed it, that means that the successor legislation that includes the same language should be interpreted the same way as to allow the president to do that. So really interesting sort of legislative history argument that got made then.
So Nixon was a great example for the government. And Kavanaugh wants to know, Kavanaugh is always trying to understand all the different ways this opinion can be written. So Kavanaugh wants to know what we can take from Nixon. The government says that 2 years before IEPA, the court had interpreted regulate importation to include tariffs, like we said. And remember, Nixon has slapped that 10% tariff on all trading partners. Now, Justice Barrett comes in, very professorial, and she says, okay, if you are saying regulate importation to mean taxation, can you point to somewhere else within the statute, within the code, where regulate importation means tariff? This is like a lesson in statutory interpretation. These are all the questions you should be asking when you're trying to define a statute. That's a great question, because if it's defined elsewhere, if the word taxation is used elsewhere, then that may mean that it's supposed to mean something different, right? Now, the answer to this is no. There is no other place in the code where regulate importation is meant to mean tariff. The government then, instead of relying on the code itself, because it has nothing else to point to, goes back to one of the oldest Supreme Court cases, Gibbons versus Ogden, to note that 1824, just like the year that Brett graduated law school. They go to Gibbons versus Ogden to note that regulating commerce allowed tariffs. Now, historical pedigree of giving the president wide latitude to impose tariffs for regulatory purposes goes all the way back to the 1800s. So the government saying you don't have to just look at the code of IEPA. This is actually something that is so ingrained in the powers that we give to the president to regulate importation. So it doesn't have to be spelled out, because it is something that is just inherent in the major powers of the president.
And of course, then Kagan comes back in and she's like, you keep talking about regulating imports and regulatory everything else, but these are tariffs. These are taxes. Regulate doesn't mean tax.
She just cuts to the bottom line, right? She's like, no.
Yeah, and the government keeps coming back and saying these aren't revenue raising. They're regulatory imports.
I didn't mean to put the hole in the wall. It just created it.
Yeah. The problem with this, I mean, number one, we have a client control issue, right? Because the client loves to talk about how much revenue are being raised by tariffs.
The client in this case, if you're missing the point, is President Trump.
And he's President Obama had a pin in the phone. President Trump's got X and True Social, and he loves to use them. He was even like, yeah, when they were talking about tariffs in the Supreme Court, they got the numbers too low. It's actually closer to $4 trillion we've raised. And it's like, not helpful. Not helpful. I'm trying to say it doesn't raise money. The raising money is incidental, is what the government's trying to say. Like, sure, it raises money, but it's incidental. Now, this felt like a real weakness for the government's case while the government was talking. Once the other side starts talking, you see how it gets flipped on them. And then all of a sudden it's like, Actually, okay, I kind of see what they're saying, but we'll get to them in a bit. So then the Chief Justice, who loves the major question doctrine, he comes back and he's like, hey, like seems straight up major questions. No one's ever done this before. I mean, sure, Nixon kind of did it. But other than Nixon, who's not the best example, right? I mean, you don't normally want to just be pointing to Nixon for like, oh, it's okay because Nixon did it.
And he is the
Nixon
only
precedent.
example, by the way. So
The only
he is
one.
the only example here.
The only one. And so it's like, look, this is a broad power you're claiming. You would expect Congress to be specific, and Congress wasn't specific. And so the government keeps falling back on this position. They're like, look, they were specific. Regulate imports includes tariffs. It's always included tariffs. And this is sort of their thing. Like, tariffs have been the way the government has controlled imports for all time. So they wouldn't need to put it in there. It would be redundant because it's already in there when you talk about regulate imports. Now, then, one of the more interesting things that happens in this case, because the thing is, if you're out there in the world and you're listening to this, there's probably like a natural hesitancy to give the president the power to reorder our economy. You're probably like, look, could they really have meant to give the president this power to impose these tariffs just willy-nilly because he says there's an emergency and like raise the prices of everything? Well, here's the problem, and this goes back to how broad the statute is. Sotomayor comes in and makes the argument that's like, hey, we all agree, right? I mean, the statute would allow the president to ban importation altogether. Now, he can do that. And everybody's like, yeah, of course you do that. It's like, wait.
He can do that.
Wait a second. And this is going to come up. This becomes a big problem on the other side. IEPA, unquestionably, understand what I'm saying to you right now. 9-0 on the Supreme Court, without question, without argument, gives the president the power to say tomorrow, fine, I can't tariff people, no more imports. I'm embargoing every nation. We will have no imports until this problem is dealt with. None. Zero. Everyone agrees IEPA gives him that power.
And those of you following this argument, that's way broader than the power to tariff. Like, way broader.
Way.
And it's Sotomayor who brings up that the statute allows the complete bar of all importations. Let that sink in for a second. These arguments have real consequences here. The government's like, great. Yeah, we agree with you. It does allow. And if you read the text of the statute, there's no need to interpret anything there. It says to regulate importation. To regulate importation, this is why it's completely unquestionable, 9-0 on the Supreme Court, is to also bar all importation.
It doesn't just say that. It says block.
Block. That's right.
Void.
Nullify.
Prevent. Prohibit. Withhold. Like,
says it 10 different ways.
You don't need to regulate. Like, there's no question that IEPA gives the president the power tomorrow. Like, if the Supreme Court would issue an opinion tomorrow and say you can't tariff people, he literally could come out and say, fine, no more imports from China. You want to import in our country, you come to the table. Right? I mean, he can do that. And that is the power that IEPA gives. And what I want you to hold in the back of your mind, because Justice Thomas, immediately after this, it's so interesting. So Sotomayor says that, like, well, obviously the president could just ban it, right? So she says that. And the government's like, yeah, sure could. Then Justice Thomas comes back and says, let's talk about the non-delegation doctrine. So the non-delegation doctrine is basically a doctrine that exists only in theory. So there is an idea that there is a point where Congress cannot delegate authority to the president. The Supreme Court has never found that point. They've sort of suggested it exists. Every time it comes up, it's rejected, to the point that most law professors have said that the non-delegation doctrine is basically a dead doctrine.
Yeah.
Just doesn't
It's
exist
like
at
the
all.
limit does not exist. Literally, there's been no case where they've been able to say this is a non-delegation. So far, it's a theory with no teeth.
So you have a situation where you have a statute where Sotomayor says, and the statute says, basically the president on his own can halt the economy of the United States. And the government's like, yeah. And she's like, yeah, everybody agrees to that. And then Thomas comes in and says, okay, let's talk about non-delegation. Is there a non-delegation problem with the statute? Does the statute delegate so much authority to the president that Congress has essentially vacated its constitutional responsibility to regulate commerce? And this is a great question. And if that scenario we had talked about before, where President Biden had done the thing where he declared the climate emergency and then said, I'm putting a 1,000% tariff on all oil and all carbon fuels, on all vehicles that come into the United States that aren't electric. If he had done that, people on the right, when they brought the challenge, they would have said, this is it. This is the non-delegation doctrine. This is where we take our stand, right? And so Thomas is making that point. The government's position is, okay, even to the extent non-delegation does apply, it applies to domestic conduct, not foreign policy stuff. We basically said that, like, in the foreign context, because the president's commander-in-chief and sort of the representative of the government, that we can delegate more of this stuff. I mean, and I understand what they're saying, but given that Article 1 of the Constitution makes it clear that this is a domestic issue, like Congress is supposed to be dealing with this, I didn't find that to be all that convincing, frankly. And I don't know that Justice Thomas did either. We'll have to see.
I could almost, you can only listen to this audio. I wasn't there to watch the arguments. I could feel a smile in his question. Like he was like, I was waiting for you to make that point. Let's come here. And so Gorsuch goes even deeper there, right? He doesn't let it go there because this is a very interesting question. It actually jumps around a little bit because the justices are all vying for time as well. If you listen to these arguments, one major thing, especially with respect to very experienced Supreme Court litigants, is that your prepared remarks are about 2 minutes long. The rest of the time is answering questions from the justice. So both sides, both Neil Katyal and John Sauer, spoke for about 2 minutes. They made their top line points. It was like bullet points, probably 3 bullet points, and they were done because all of the meat is in answering each of the justices' questions as they're trying to figure out how they would write this opinion and how they get 4 others on their side to have a majority in order to write this opinion. So this jumps around a little, but I'm going to go to what Gorsuch says because he digs in deeper on the major questions and the non-delegation doctrine question. He's like, look, could Congress actually delegate to the president powers that are explicitly listed in Article 1? Isn't that the logic of your view? Now, the government says, no, you don't have to be concerned about that because clearly there's a problem there. If Article 1 essentially becomes Article 2, then there are no articles. Then you don't have the checks and balances of the 3 branches of government. Then you have one king. And that's exactly why we fought the Revolutionary War for, right? That's the problem that we're facing. And so Gorsuch is like, isn't that what's happening here? What is the difference between Article 1 and 2 if Congress can just say, this is too hard, I'm going to grant you, delegate all of my Article 1 powers to you, Article 2. And the government, as they have to push against this. They say, no, we don't need to be concerned about that. This is not what's happening. It's not a non-delegation issue. Because this is foreign affairs. Now, Gorsuch says, okay, how do you draw that line? Where do you draw the line that that's actually foreign affairs? I mean, could you declare war? Could the president declare war? Can he regulate foreign commerce? The government points to the inherent authority that the president has, but Gorsuch does not let Sauer go. He's like, he's not going to let him wiggle away.
They keep talking about this foreign authority, but that is not the way the Constitution is written. The Constitution does not place all foreign-facing authority in the president. You can imagine a situation in which it did. That's one way to structure a government. Congress has all domestic authority. President has all foreign authority. And then we have the court doing whatever it does, right? You could do that, but that's not what they did. As Alice said, in response to sort of the problems that they saw in the way things were run under the English king, they wanted to take some of the inherent authority that you typically think of as residing in a king, like declaring war. Seems like something a king would do, right? Well, not in our country. That is specifically Congress's power. And there's nothing more foreign-facing than declaring war. So this, it's foreign-facing, it's foreign-facing. Who cares? Now, look, their argument would be, and Congress delegated it. Right? And they will repeatedly say, we are not saying the president has inherent authority to put tariffs in. But once they delegate it, he can. But Gorsuch he's hammering on this non-delegation thing, and it makes sense.
Yeah, and he kind of takes that hypothetical that was presented in the briefs and first brought up by Sotomayor. He says, okay, government, I hear you retreating right now. And he keeps saying that. He's like, are you retreating from your position? There are a lot of laughs from the court because he's really keeping his thumb right on the government. He says you're retreating, that there is actually a major questions and non-delegation issue that we're facing here. So you're pulling back. And he calls that as a win. And, the government kind of dances around that. So then again, Gorsuch comes back and says, let's go back to that climate change emergency example. Could the president, under a climate change emergency, impose 50% tariffs on gas cars to deal with climate change? As we've already said, the government only has one answer here. The answer has to be yes. And that's what John Sauer says. He says yes. That he can do that under IEPA because it is that broad. Now, Gorsuch notes that most of the authorities of this happening are all in wartime. And the government also says, you're right. Most of this is happening in wartime, and the power is broader during wartime. But he said this is in a foreign affairs context. So although it's more limited, it's also broader than in the domestic context.
And he gets hammered on this a lot. I mean, under IEPA, there have been a lot of emergencies declared, but none of them have
not in wartime.
Tool. The tool used by the president has never been tariffs. It's always been something else, right? And Sauer's like, yeah, but these are uniquely situated for tariffs. Like, that's why this is happening now for the first time, other than Nixon.
I skipped what Kagan had said. I think it is, a lot of you may be thinking about this. There's just so many lines of this argument. So tariffs has never been used until this context, but she's also like, wait a second, every other tariff statute has limitations on how high the tariffs can be and how long they can last. So it's not this unlimited power that you can slap on 100%, 1,000% tariff forever. Usually it's something like, okay, up to a certain percentage, and it's going to expire sunset in 6 months, 12 months, 18 months. So we do have statutes that we can look to that talk about tariffs, and they have these limitations, but this one doesn't have it. So this is not like all the other tariff statutes, because you keep saying the Congress meant to say that tariffs were included within the regulate importation, but somehow this doesn't read like the rest of it. And the government said, well, there is a limitation. Sure, there's not like a sunset clause on it or, a percentage cap, but the limitation is on national emergencies. And Kagan goes back and says, but we all agreed. The declarations of emergencies are basically unreviewable. So essentially, there is no review and no cap at all. It's unlimited power. And so we're right back to that major questions, non-delegation issue of, is this just all Article 1 being delegated to Article 2?
And there's a lot of realpolitik going on here, because the government wants to say, look, Congress can vitiate, I'll use that word, the emergency at any time. Congress can pass a law saying the emergency declared by the president is no longer in effect. But everybody's like, on the court's like, yeah, but then the president's going to veto it. And then the government's like, yeah, well, they can override his veto. And everybody's like,
they're not going to do that.
And so do I. At one point, it's like, they can't even open the government. Like,
Which is true.
How are they going to override the president's veto? And it's like, how much does reality matter when you're making these kind of arguments, right? So Kavanaugh, look, whatever's going to happen in this case, I mean, I hate to predict based on oral argument because you never know. But of all the justices, it seemed like Kavanaugh was the most pro-government. And you see that in this set of questions. So he wants to go back to this major questions doctrine, right? Because I think he anticipates this is something that the one thing about Kavanaugh, little inside baseball here, Kavanaugh, I think, sees himself as the chief whisperer. He views himself as someone who can get the chief on his side, and that's one of his strengths. And so when you watch him in arguments, the chief typically is his main audience, right? And the chief cares about the major questions doctrine. He says, look, was this really the kind of power that would have been unheralded at the time of the statute? Because that's one of the words I use in major questions doctrine is it unheralded? Would no one have even seen this coming? And he notes that, yes, since IEPA has been passed, no president has done this. But then he talks about Nixon and the predecessor statute, and he just lobs up a softball to Sauer. And he says, hey, what do you think about the fact that, as we said earlier, the same language that Nixon used to impose a 10% tariff on the world was included in IEPA even after he did that? So he does that under the predecessor statute. It's upheld. Congress has an opportunity to limit him. And what do? They use the exact same language. And the government just knocks this one out of the park because it's a softball, really hammers on that. And they then start talking about prior cases. There's a case called Algonquin that comes up a lot. This was about a statute that allowed for adjusting imports, and Algonquin said tariffs were the kind of thing you would use to adjust imports. And Kavanaugh, once again, sort of lobs up the softball. He says, shouldn't regulate imports mean something different? Because if tariffs are including and adjusting imports, then what about regulate imports? And this allows the government to say that the second definition of regulate is adjust. So you can see how it's a very sort of friendly back and forth. And I think this indicates that Kavanaugh is looking to get to yes on this. I feel like, telegraphed his position more than most. I mean, obviously, I think we can say that Kagan, Sotomayor, and Jackson are going to say you can't do this. But when we're looking at getting to 5 for the government, I think you can say you got 1 in Kavanaugh at this point, at least.
So Barrett comes in and says, okay, we've been talking about the regulate portion. Let's go back to the means in which the IEPA allows the president to take all these actions. And they are a smaller list. It's instructions, licenses, or otherwise. The or otherwise really is doing a lot of work here. And that's from the statute. So she says, does that include tariffs? Is it within instructions, licenses, or otherwise? I would say it's within the otherwise probably, but saying are tariffs licenses? Now, the government regulates imports naturally include tariffs, and listing tariffs again would be redundant. So they're like, yes. Now, Barrett says, does this give the president, we're all talking about the government here, does this give the president the power to tariff basically everyone? China maybe, but why some of these others? I think she brings up like Sweden, our ally. Switzerland, our ally. Sorry, Swiss banks, of course. What am I thinking? Now, the power is broad, says Sauer, because the emergency is broad.
And I mean, honestly, I get why she asked that question. You're not going to draw that line.
No.
The court is not going to say, okay, fine, you can tariff China, but you can't tariff
anybody
Japan.
Else.
They're not going to do
They're not going to do it.
Right.
But really,
so
we beat all the argument. I mean, it is, I think Sauer is up there for more like an hour and a half. And he's supposed to argue for what? Isn't originally it's like, I think they have 30 minutes each, right? And then you reserve 5 minutes at the end. So the whole argument's supposed to be an hour. So he's up there for an hour and a half, right? Oh, yeah. I think they do 2 rounds of last questions, in fact. And then, of course, Neil Katyal, who's arguing for the other side, he is no stranger to the Supreme Court. Obviously, he was a former Solicitor General of the United States.
Argued the Obamacare case.
He argued, which was a case that won on taxes. And that's what he says within his first opening. He says, this is a tax. It's a tax, it's a tax, it's a tax. It was very effective, actually, because we had all these questions round and round about the major questions, non-delegation doctrine, all these kind of high, lofty ideas. And he comes in and is like, this is very clear. A tariff is a tax. The president cannot do this under IEPA. Now, he was asked if this is an embargo. And can you do an embargo because it's not a tax? Now, which is a good question. This is the flip side of what we were just hearing, right?
And I mean, look, I feel like if you read the coverage of this case, I feel like most people, they just listened to the questions to Sauer and then wrote their columns, right? And they're like, oh, he really got hammered. Well, of course he's going to be hammered. They really got hammered, right? But then when you get to Katyal and they start hammering on this question about embargoes versus tax. And look, I have said this before. When it comes to the highest level of the law, there's really a point where it's just like, what do you feel? like, does this feel right to you? Right? And so essentially, Neil Katyal is saying, yes, just like we said before, yes, the president could embargo the world because Congress delegated that authority to him to shut down trade altogether. But man, if he imposed a tariff, that's unconstitutional.
Like a 1% tariff.
A 1% tariff. 1 cent. He couldn't put any tariff, less than a cent of a tariff. He could shut down trade, but he can't put a tariff because that's a tax. And there's something so formalistic about that. Now, look, formalism when it comes to the Constitution actually matters because it is a formal structure of government. So, yeah, sometimes it's crazy the things the government can do and can't do just based on how the powers were sort of meted out. But I will say it doesn't hit me is that sort of convincing that, well, it's a tax though. So yeah, I mean, he could say no trade at all, but he can't impose a tax. I don't feel the power of that. But that is the central argument he's making. And one of the reasons is because he can't bring himself to make the non-delegation doctrine argument.
So there was a real laugh out loud, or I don't know anyone else who laughed out loud. I laughed out loud when there was that exact exchange where Alito kind of called him out on it. He's like, are you going to be known as the lawyer who brings our first non-delegation, real non-delegation case? And Katyal chuckles. He's like, and he just kind of moves on, right? Because that's what he dances around. But this is such a, look, if you can remove all the political emotion from this is as close to non-delegation as I've ever seen, and there's never been a case, like we said, of non-delegation, because if you read the statute, man, it's broad. We'll get there later, but not tipping the hand here, just it's really big, but he can't come around to it. And then, so remember what we said on the other side, there's only one case that the government can point to where this has happened before: Nixon. Well, this is what happens in the court of law. You do an about face. So that's also a case that Katyal has to deal with. So Kavanaugh says, okay, what about Nixon's case? Isn't that ratification of the regulate importation clause right there? And Katyal says, well, no, that's a case dealing with Nixon tariff. That's not a Supreme Court case. We've been talking about it here. That's ratification of the language, whatever. That was just a court of appeals. We're here at the Supreme Court, the Supreme Court law of the land. That doesn't matter here. And he also notes that Section 122 of the Trade Act allows for limitations on tariffs. It's a 15% tariff for 150 days. And that is not what we have here. We talked about this earlier. No limitation whatsoever in the way that the government reads tariffs into the regulate importation. And Katyal says, look, this would completely swallow the limitations on trade power.
So then Alito comes up, and if your whole argument's going to be it's a tax, well, why is it a tax? They can call it a tax. Well, it's a tax because it raises money. That's the argument, right? Just like the individual mandate. If you didn't get insurance, you had to pay money to the Treasury, so therefore it raises revenue, therefore it's a tax, right? And that's essentially what Katyal's saying. So Alito points out the problem with that. He says, okay, could you impose a fee? And, Katyal's like, fees, is raising revenue or whatever. And so then Alito proposes a hypothetical, which is just the bane of having an oral argument next week. And I'm always trying to imagine the hypotheticals, because it's the hypotheticals that get you, right? You're good on the case in front of you, but the court never wants to talk about the case in front of you. They just want to talk about the hypotheticals. So Alito's like, okay, let's say the president declared an emergency. The national parks are just derelict. There's too much trash, whatever. We need some money to fix up the parks. And the president says, to address this emergency, I'm going to impose a fee on every person who enters the park. Can the executive do that? The fact is, he doesn't have to declare an emergency to do this, because this is well within the executive's power. And everybody knows he can impose a fee, right? I mean, that's the answer has to be yes, is the problem. Because of course he can, right? So Katyal is like, well, he could do that to cover the cost, because then, it's not raising revenue. Now, look, Alice is an actual economist. I took Economics 101. My recollection is there's revenue and then there's profit. And revenue just means money's coming in. That's all it means. It doesn't mean you're making a dime. That just means money's coming in. He's talking about profit. He's saying basically, if the government's making a profit off the fee, then you can't collect it. But that's the problem, because clearly the president can impose the fee, which raises revenue. I'm sorry, it just does. It brings money in.
The revenue covers the cost, and when you net them out, you have zero profit.
And so, essentially, what Alito, he's got him, in this pincer, right? Because it's like, no, you've just admitted the president could decide to do something for the purpose of other things related to the park, limiting access or whatever, because if you put a fee on it, there's going to be less access, right? And the fact that it raises revenue is irrelevant. It brings in money is irrelevant. And so he tries to dance around this. And it's just a really difficult place to be because, frankly, once Katyal starts talking, all of a sudden the government's argument about what really matters is the purpose of the thing. Is it regulatory in nature or is it really intended to raise revenue? Matters, right? And the government's saying, look, it's not just like the fee on the park is meant to limit access, repair some stuff. It's not really meant to benefit the Treasury. Just like that fee is legal, so too are these tariffs. And honestly, I didn't feel like he ever had a good answer for this. I don't think he ever really got around this because, honestly, I don't know that the answer is that it's a tax. I think the answer is probably it's an overbroad delegation, but he's never going to say that. So he sort of gets in this place, and Alito keeps hammering on it. He's like, okay, fine. What if the president imposed a tariff with a 90-day delay? He said there's going to be a tariff. Let's say I'm going to put a 100% tariff on Chinese goods, but I'm not going to enforce it for 90 days. And within those 90 days, China comes to the table and says, you know what, we don't want that tariff. We'll agree to whatever, and the president takes it off. Is that a problem? Is that revenue raising? Could you challenge that? And Katyal has to say yes. Yes, we could challenge that, even though it hasn't come into effect. And it just...
And why that's hard is, remember the very first question? What if instead in the 90 days they didn't call it a tariff, they called it an embargo? You know? I mean...
Other thing, practical applications. What if the president put 1,000,000% tariff? 1,000,000,000% tariff? The power to tax is the power to destroy, right? I mean, that's been said before. And Justice Marshall said that. You can do a tariff that's an embargo, that's so high that no one will pay it. Think about cigarettes. There was a time when the cigarette tax was intended to raise revenue. That's why we had it. Now, we have increased the taxes to a point that when you increase the taxes, you actually reduce your revenue. Because why do we keep raising taxes on cigarettes? Not because we're raising revenue, because we want people to stop smoking, right? That's what we're doing. So... You know, I mean, the president could put like a $1 million tariff on cigarettes. Obviously, no one would ever buy cigarettes again. So this notion that like an embargo is okay, but a tariff isn't, when in reality, they both can serve the same purpose. It's just, you're getting sort of in this weird place that the argument just doesn't feel.
This is the definition of semantics, right? And so Gorsuch comes in with more semantics. It's like, okay, can we just call them licenses? Let's not call them tariffs. Like, Trump, go back and retweet everything. This is just a license. Does that otherwise encompass tariffs? And Katyal says again that this is a tax and duties, and the precedent says that you should interpret those statutes narrowly. And then he falls back on Katyal's like, look, this is really a major questions argument. We're going full circle. He agrees with Justice Thomas from 2 hours earlier when the argument started.
And what's crazy about it is he doesn't really want to say it's major questions. So there'll be times where he's like, well, it's not really major questions. But then he's like, actually, this is a major question. It's just like, I feel like Katyal walked into this argument with so much, there were so many places he could have gone. But I honestly feel like his own sort of political prerogatives and maybe the prerogatives of his
I was going to
clients,
say, maybe he had like a list where he couldn't cross too.
Yeah, they've really limited him and his ability to make these arguments. I mean, someone in the chat literally just said, was it a tactical error to have him as the attorney? I don't know that it's him as much as maybe sort of, I mean, there's like a dance here.
Right. He is a phenomenal lawyer. Truly is. Like, you want the best of the best arguing this. I don't know that someone else would have argued it differently because of the dance that he had to do in threading the needle on these things. It's not just him and his personal view. Obviously, this case is interesting. All SCOTUS cases are interesting because of the effect it has on all these other areas of law and in other administrations as well.
So then Alito starts talking about the Smoot-Hawley Act, which most of you have heard about the Smoot-Hawley tariff at the very beginning, 1930, the beginning of the Great Depression, and whether there are powers within that, and this question about whether it's lapsed or not, and they're having to deal with all this stuff. And Catch-all sort of indicates, well, if the president wanted to try and bring him under Smoot-Hawley, maybe he could deal with it then. Alito's like, we should deal with that now. And then you get into this whole where Catch-all's this is the point where Alice was talking about, where the non-delegation comes up and Alito's like, are you going to be the lawyer to revitalize non-delegation? And the way Catch-all tries to deal with this is he says basically, look, in Youngstown Steel, they talked about how emergency powers beget emergencies, which is a really smart thing to identify because obviously if you give someone emergency powers, they're going to be looking for emergencies to use them. And that's essentially what he's saying. And this is kind of a non-delegation argument, right? He's basically saying, look, if you give the president the power to do this, he's essentially going to have unlimited power. He doesn't want to call it a delegation problem. He doesn't want to embrace non-delegation, but he's making a non-delegation argument in a real way. And then Kagan comes in with what I think is just a fascinating question about this, which I think also goes to non-delegation. So Kagan points something out really interesting about IEPA. So in IEPA, there's a legislative veto. So one of the arguments that Catch-all's been making this whole time is Congress wouldn't have given the president this kind of power without some sort of check. Everywhere else there are checks. As Alice said, most tariffs, it's under the Trade Act, it's a max of 15% for 150 days. So why would Congress have given the president the power to impose these unlimited tariffs for unlimited times with no limitations? And Kagan comes back and says, but they did have a limitation, a legislative veto. So when IEPA was passed back in the 70s, a lot of the statutes included something called a legislative veto. And the idea was, like, let's say we give the president, let's imagine that they did give the president this tariff power. And he goes out and he puts a tariff on Brazil. Let's just use that as an example because this literally just happened, right? So Congress, under the legislative veto, could have a bare majority vote to overturn that tariff. The Senate votes on it, the House votes on it, it's done. No presentation to the president, no signing by the president, no opportunity to veto, no overriding the veto. That was a legislative veto. Recently, one of the tariffs that President Trump imposed was on Brazil, and the Senate voted against that tariff. The House hasn't voted on it yet, but even if the House agreed with the Senate that tariff shouldn't happen, it has to go to the president. That's the way it works. And the president will veto it, obviously, because he imposed it. Well, under the statute, they were trying to avoid that problem by saying, hey, we should just be able to say, we voted it down, sorry, you can't do it. Problem is, in a case called Chadha, the Supreme Court said that is a violation of bicameralism and presentment, which is the idea that for something to become law, both houses have to vote on it, has to be presented to the president, and he has to sign it. So therefore, legislative vetoes are unconstitutional. And the way we've dealt with that is just to write them out of the statute, right? So you had IEPA that gives the president all this power. It included a legislative veto, but that's been written out of the statute. And Congress never did anything else. They didn't go back and say, okay, fine, now that we can't veto things, we want to limit the president's power further. And so Kagan's essentially saying, you've been saying Congress wouldn't have done this, but if they thought they had a legislative veto, maybe they would have.
And so all of this merry-go-round comes right back to Gorsuch basically asking like, boom, 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 last questions. He's like, look, the word regulate in the statute is capacious. I think they said capacious like
so many
50 times at least. And everyone agreed that at the founding, the regulating commerce did include tariffs. So he asks Katyal, don't you need the major questions doctrine here? And Katyal again, kind of backs away. He's like, no, you don't need it because there's no context that includes tariffing. So Gorsuch says, okay, let's talk about licensing. Can tariffs be licenses? And Katyal concedes that yes, they could be identical.
Which is a problem.
Which is a huge problem. That's a huge concession.
Later on, the Oregon Solicitor General will try and say, well, it says licensing, but it doesn't say licensing fees. And it's like, come on, man. licensing obviously includes the fee that goes along with the license. Like, that's just silly. And it's funny because he totally concedes this. And then later on, he's like, well, I didn't concede.
He did concede it.
Because another justice is like, well, you've already conceded that tariffs could be licenses. He's like, well, I didn't concede that. It's like, yes, you did, man.
Yeah.
Like 10 minutes ago, you conceded that. Like, and this is one of the problems. And at some point, Justice Barrett points at something we've talked about, which is, you're saying you can embargo. Isn't a lesser included power tariffing? Isn't tariffing a lesser way to do what you can accomplish by embargoing? And look, y'all need to go listen to this, see what you think. Just reading the coverage of this case, I thought, man, this might be 9-0 against the president. It is not going to be 9-0 against the president. I am not entirely sure what the vote is going to be.
I'm not sure what doctrine it's going to go under.
I'm not either.
I truly don't know.
The only way this is 9-0 is if 6 non-delegation and 3 we just don't think the president can do this, right? So like the 6 conservatives or some combination
that 6 can
of
go with
them.
non-delegation though. Like,
Well, say 3. Well, I mean,
sure.
Here's an interesting. I mean, you could imagine. Let's say you get Thomas, Alito, and Gorsuch on non-delegation, and then the 3 liberal justices on whatever basis they want to say. The statute isn't broad enough, right? And then the other 3, I don't know what they would do.
Without
So, I mean, I
comment,
guess the other
without
3
joining any of the opinions, the president does not have such broad duties. Basically
Right,
saying
I
the
mean-
non-delegation argument without calling it non-delegation. I can actually see
Yeah,
that.
maybe Kavanaugh says he can do it, but I think Kavanaugh would be tempted by non-delegation.
I think
mean,
that might be the only way to make it like a 9-0 situation, right? Because non-delegation
Yes.
is the hook for him, even though
Right,
he's the
because he
most
clearly
capacious
thinks-
with respect to the executive powers.
He clearly thinks the statute allows you to do this.
And I would say it does.
I think
The
that's
way
the
it's
thing. Like,
read-
the taxation argument is
And
so weak.
Cantial also concedes that the statute allows it if it's the whole license is tariffs thing. But I think everyone, that's the problem here, right? I think everyone, including the justices who are on the left, everyone agrees that this is an incredibly broad statute. And all these questions dance around the fact that it's like, can we have such a broad statute? Is that okay? Is that what we want? Is this constitutional? And what happens when you flip it on its head? Because this has major implications moving forward.
Yeah, I mean, I don't know. I mean,
Seems like a clear non-delegation issue, except for the fact that it comes such a loaded doctrine because it's not really a doctrine. It's like the Loch Ness Monster that I don't know if it can settle. But if there ever were a case, this seems to be the non-delegation issue.
And I mean, another issue is it's been around since the 70s.
And no one has...
TWIA
Yeah.
passed in 1917. So we're talking about basically
110-year-old statute.
a really old statute that has been used many times to address various emergencies. You want the president to have the power to address emergencies, right? I mean, and the other examples, they make sense, right? Why you would do this. I mean, ITAR, we talked about ITAR earlier, which is the Iranian trade and whatever, right? So IEPA, in the wake of the Iranian Revolution, the president says it's in the interest of the United States to limit certain products going to Iran. So basically, anything that could help them, assist them in like their nuclear program and all that other stuff, you can't send to Iran. You can't send them like Windows 95, or anything after that. So that seems like something the president should be able to do. Well, he did that under IEPA. I mean, that was the basis. So if you say it's non-delegation, then you're striking down the whole freaking statute, right? And maybe you need to do that, but it seems like it's not wrong, but it seems pretty extreme. And typically they don't like to go that far, right?
Especially when
I don't know.
Congress wrote such a broad statute, took away the legislative veto, right? Like, there's a lot of problems here with respect to, like, Congress did this.
Look, honestly, if the statute is constitutional, it is so broad, I don't know how the president doesn't have the power to do this. That's the problem. So I just don't know. I mean, are they really going to say it's a tax and therefore he can't do it? I guess they could. That just seems so weak.
I know.
It just seems like such a weak position.
I mean, they've done it before, so they can do it again.
Yeah. I think, okay, so it feels like Thomas and Alito have delegation doctrine problems, right? Gorsuch does too. Gorsuch feels like he doesn't really couch it in non-delegation, but he seems to have a real concern about this statute giving this much power to the president.
Honestly, so does Kagan, but she would never call it non-delegation.
Kagan does too. And Kagan's point about the legislative veto thing is interesting. Yep. So maybe, I mean, you could have a really strange, let's imagine those three, non-delegation, the other three, statute isn't that broad. So basically you have 6 votes to strike down the tariffs, but not on the same theory at all. And then the other 3 say the president could do it. But the thing is, I don't know that the other 3 would say the president could do it.
That's why I think it's all going to be on different theories.
So maybe it is going to be 9-0. I don't know.
But no, controlling opinion.
So,
or they'll take a page from redistricting and just re-argue it.
So the way the president can win, and let me also say this, I don't know if they can do this, but there was some talk at the end about how you unwind the tariffs, which is a nightmare. I almost feel like they should say this is a looking forward opinion. Any tariffs collected up to the point this opinion was issued are fine.
We're just going to call it a fee. Yeah.
It's totally perspective.
We're just going to call it a fee.
Those were licensing fees.
Everything going forward is a tariff.
So I think, I don't know. I mean, I guess I just don't know. I keep going back to this.
Or they can just read some limitation.
Kavanaugh, you could have Kavanaugh, Barrett, the chief.
Call it a license?
It's hard for me to get to 6.
Call it a license?
Well, I don't even know if they have to call it. I mean, so Barrett's arguments were very much like, look, if you called it a license, it can't be the case that you called it a tariff, therefore it fails. If you could say, in order to import into the United States, you need a license, and the fee we're going to impose is 15% on all goods.
I still feel like we have to fall back to non-delegation because the problem is everyone agrees on the embargo issue. And so you can strike it down because what everyone agrees. I just keep falling back to non-delegation. But I don't know I don't know. I keep coming back to that.
This is so clearly a non-delegation issue to me.
It is a non-delegation issue. I just don't know that they can come to it and call it because the problem is everyone agrees. And I don't know that everyone agrees everyone agrees the statute says that there can be an entire embargo. Willy-nilly, as long as there's an unreviewable emergency. Everyone has a problem with the fact of that lesser included. And tariffs are 100% a lesser included. So it's non-delegation. That's what I keep coming back to.
And I don't think it's a major question because...
I don't either.
This is such a broad grant of power. Clearly, Congress intended to broadly grant. This is not a situation where they did.
And it's the executive. It's for there are all these issues. It's an interesting question, but it's not. It's non-delegation because I think it's clearly been delegated in this statute. But we have a problem with the fact that they can do that.
Would the Supreme Court strike down a statute and the tariffs when the people challenging it are not making the non-delegation argument? I mean, they can do whatever they want.
They can do whatever they want. And that's why I don't think so. That's why I don't think they will.
I just don't think they've got the guts.
I don't think they have the guts because you don't even have Katyal who has the guts to say it out loud when that is his winning argument.
Okay, so if they don't have the guts to strike it down on non-delegation, then it's going to go one of two ways. Either they'll say, this is such a broad delegation of power, it includes the power to tariff, the tariffs are okay. Which honestly, I think is the most
likely,
intellectually consistent way to view this.
And it's, by the way, basically all the underlying opinions come out to this result. Basically, anytime the president does this under IEPA, it's been upheld. I did a survey of all cases. This is now 6 years ago when I did it. But there was no instance where the government has lost. Ever.
The president's never
lost.
Now, he hasn't been tariffing people, but nevertheless.
Not tariffing in this way, but every time it's been invoked.
So that's 6-3 if it goes that way, right? So I think if they uphold the president's power to do it, it's maybe 5-3 and then Gorsuch dissenting on non-delegation. I don't know. The non-delegation just keeps getting in my head.
I can't not see it. It's when someone points out the elephant in the room. I'm like, I keep seeing it. Non-delegation.
Yeah, it's right there. Non-delegation is right there. If they strike it down, then I think you have some group of justices who say it's a tax and tax isn't included in the power. And then maybe a couple non-delegation. I don't know.
If non-delegation is not part of it, I wonder if Thomas will just write a very long dissent or concurrence on it.
I just feel like if the challengers had gone in full-throated non-delegation, 100% non-delegation, right? The 3 liberal justices would have raised the tax issue on their own. They'd have been like, it's really a tax. It's really a tax, so you have to strike it down because the president has power to tax, whatever. If they had gone full-throated non-delegation, I think they would win.
I agree.
But they didn't do that.
They didn't. And someone's crying about it upstairs.
Yeah. So I guess we'll see what happens.
Well, this was a very brief 20-minute episode, so,
Legal briefs.
Legal briefs. You can read the briefs online. You can listen to the argument online on podcast form. You should as well, because you shouldn't take our word for it. It's a fascinating argument. This is like core what you argue, and there were great litigants on both sides. Fascinating questions by all the justices as well, and really meaty questions. Like, even though this seems like just a political issue, it actually invokes some of like the most age-old doctrines of our form of government, and they are very interesting to think about. So we've been going long enough. We will let you go for today, but maybe we'll do an entire episode of questions, because we will answer your questions if you leave a 5-star review. We don't check if you've asked multiple questions, so just keep sending in those 5-star reviews. Keep asking us questions at prosecutorspod@gmail.com. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Sometimes you kind of start to whisper when you get passionate.
Do I whisper?
You get like just like that.
Do I whisper?
When you're like really being heartfelt and serious.
Okay, I'm not going to be heartfelt or serious. I'm going to be very loud.
I mean, we're talking about the Supreme Court, so I don't know how you get
I get pretty passionate.
We're much more likely to yell.
I get pretty passionate about it.
And you already got heartfelt. Okay. Well, I think I'm ready. Okay. I'm ready whenever you are.
Yeah, I had a great descriptor for you. Now I've forgotten it. Okay.
This November, action is free on Pluto TV. Go on the run with Jack Reacher.
Every suspect was a train killer.
Then buckle up for Drive, World War Z.
Every human being we save is one less to fight.
And Charlie's Angels.
Damn, I hate to fly.
Launch into sci-fi adventure with The Fifth Element and laugh through the mayhem in Tropic Thunder.
What is going on here?
All the thrills, all for free. Pluto TV. Stream now. Pay never.
Shopify is a platform built for growth, whether you're just starting out or already running a thriving business. From managing inventory to creating a seamless checkout experience, Shopify is designed to handle it all. And it doesn't stop there. Shopify helps you sell everywhere your customers are, online or in person. It's the ultimate tool for turning big dreams into big wins. Sign up for your $1 per month trial period at shopify.com/OPP,